Welcome to the afternoon session of the Court of Appeals. Let me introduce our panel for this afternoon. We have Judge McGee from Savannah, Judge Smith from Memphis, and I'm Kenny Armstrong from Memphis. You probably already know this, but when you come up, if you would introduce yourself, and if you're representing the appellant, you can reserve as much as 5 minutes, and you'll need to make a decision then about how many minutes you're going to reserve so we can set the timer. And you've probably seen this timer before. If the light's green, you've got plenty of time to make your argument, but once it turns red, that ends your time. Do we have any matters we need to take up? Ms. Ashley?
No, Your Honor.
All right, you can call the first case then.
Joshua Matthew Brown versus Kimberly Higginbotham Brown.
Good afternoon, Your Honors. I'm Russ Edwards from Sumner County. If I could please reserve 3 minutes
Okay.
for rebuttal. Obviously represent the appellant mother in this appeal. I do have my high school speech and drama teacher behind me. She's one of the attorneys, Kim Johnson, who's on the docket today. So, many moons ago. But today the most important issue is discussing the parenting plan between the parties that the Sumner County Circuit Court adopted and we've appealed. But the only dispute, the parties have 3 children. The only dispute is with Lisa, who is now 9 years old. She was adopted by the parties in 2018. They were her foster parents before that. Their other daughter, Anna, is now 16 years old. The parties agreed that the mother would be the primary parent of Anna, the 16-year-old, and live primarily with the mother, and they agreed that the father would be the primary parent of Noah, who is now 18, so he's aged out, and Noah lived primarily with the father. But the mother, she was a stay-at-home mom during almost the entire marriage. She homeschooled Anna and Noah, which was done by agreement. And the proof at trial showed that the mother was the parent most actively involved in Lisa's education. When asked, the father did not know much about Lisa's basic care, such as her clothes size, the name of her dentist, or what medication she had been taking since age 7. And it was undisputed that the mother was responsible for a majority of the parenting responsibilities for the children, including laundry, doctor, dentist, appointments, haircut, school, transportation, things of that nature, practically everything. And it was also not refuted the mother was responsible for disciplining the children. The father admitted that the mother was the primary caretaker of all the children. And the proof at trial showed that the parents have not been able to effectively communicate with each other on parenting matters. The father introduced some text messages between the parties, and he cherry-picked the text messages that helped him the most. And the father even admitted when questioned that introducing the messages at trial might cause the mother not to trust or communicate effectively with him. That's what he admitted. The mother does not have confidence that the parties will be able to communicate effectively about Lisa after the divorce. While the parties were in counseling together at their church, the father even revealed to the mother and others that he wished for the mother's death or his own death. He admitted that. The father revealed to his counselor that his emotional needs were being met by the children. He testified he has a safe place in the house, and the mother testified to this too, a closet, which is the only place that he feels safe and where he spent a lot of time. And the father admitted that he has abnormal emotional reactions to normal situations. But despite all this evidence and more, the trial court adopted the father's proposed parenting plan regarding Lisa, which named the father as the primary parent of Lisa, and ordered equal parenting time between the parties. We would submit that the weight of the evidence preponderates against the trial court's findings in this regard, and that the trial court should be reversed and the mother's parenting plan should be adopted, which names her as the primary parent of Lisa and gives the father every other weekend. There's no kind of, we're not proposing any kind of supervised parenting time, or it gives him an adequate amount of parenting time. And the proof at trial supports this request. Lisa and Anna are very close to each other. As I mentioned, Anna's the 16-year-old. The father even testified it's in the children's best interest to be with each other in the same home together. As the court is well aware, there are a number of statutory factors courts are to consider when making a best interest determination and when fashioning a parenting plan. Number one is and that's under 36.6-106A. One says the strength, nature, and stability of the child's relationship with each parent, including whether one parent has performed a majority of parenting responsibilities related to the daily needs of the child. The trial court made a finding that the mother performed a majority of the caregiving tasks for Lisa, a role she served well and faithfully. That's quoted by the trial court in the court's findings. And that the mother has been the primary caregiver for the party's children prior to these proceedings. That's the court's findings. I'm quoting the court. This factor obviously favors the mother. The court did focus admittedly heavily on factor number two. The court said, I'm relying not exclusively, but heavily on factor two, which is each parent's potential for future performance of parenting responsibilities, including the willingness and ability of each parent to facilitate and encourage a close parent-child relationship between the child and both parents. The court found that the mother failed to facilitate a relationship between the children and the father. In doing so, the court focused heavily on the relationships between the parents and Anna and Noah, and more specifically, what transpired between them after the father filed for divorce. The trial court appeared to hone in on what transpired between the first and second days of trial. Well, there's a 2 days of trial, but they were spaced out about a month apart from each other. And there were some text messages after that the father introduced on the second day. The trial court really focused a lot on those communications in making its ruling.
Mr. Edwards,
Yes.
Let me ask you this. What can you point to in the record, what evidence in the record can you point to that would preponderate against the trial court's findings as to this particular factor? Because the court evidently thought this was a very important factor, as you stated. And what specifically is in the record? I've read your briefs, but obviously I hadn't been through the record. What evidence was presented? Do you feel that, or are you arguing that the trial court missed or misconstrued to arrive at the conclusion it did as to this factor?
To the second factor? Well, quite frankly, the text messages introduced by the father, I think those were primarily the evidence that the court focused in on. That's the evidence, there was some testimony between the parties too. It's really what transpired between them between the first and second days of trial. The court just thought that the mother was not doing enough to facilitate a close relationship between Lisa and the father.
Is there any evidence in the record that you would point to that would draw a different conclusion?
The mother's testimony in that regard. The mother didn't refute that. She sent these text messages, and she testified that she's not trying to interfere with the relationships between the father and his children. So her testimony would be the primary evidence in that regard.
Thank you.
But right after the trial, when the tensions were obviously at the highest, at their pinnacle, should not define the parties' behavior during the course of their marriage or determine Lace's future. The heavy weight the trial court placed on what transpired after the divorce proceedings began, including the text thread, should not overshadow the mother's role as the primary caregiver for the children since their birth and since their adoptions. A role that was praised by the father, and that role was praised by the trial court. So the evidence preponderates against the trial court's finding in that regard that the mother failed to facilitate a relationship. And really, it's primarily on the father's job to facilitate a close relationship. But she did nothing to interfere with that. I'm only going to talk about one other factor, and that was factor 10, statutory factor, the importance of continuity in the child's life and length of time that the child has lived in a stable, satisfactory environment. This was not addressed by the trial court, but the continuity of Lace's life is of utmost importance here, and the mother has faithfully performed her duties as the primary parent of the children, so this factor favors the mother. Other statutory factors which are addressed in my brief either favor the mother, are neutral, or are not applicable to this case. The case of Darva Manish, I think I'm pronouncing that correctly, that came out 20 years ago, held that equal parenting time arrangements are appropriate in certain limited circumstances and are generally disfavored by the courts. Skip ahead to 2020, last year, and McDonald v. Koffel, an opinion from the Tennessee Court of Appeals, held that consideration of a child's best interest outweighs consideration of the policy favoring a parent's maximum participation with the child. The court said the best interest of the child, not maximum participation possible concept, remains the primary consideration under the governing statutory scheme. In the case of Rajendran, which came out of the Tennessee Court of Appeals, I believe the Western section, the court overturned the trial court, the Sumner County Circuit Court, in awarding equal parenting time between the parties, vacated that ruling and remanded it to the Sumner County Circuit Court. And the court there held that the lack of trust and inability to cooperate were the barriers to joint parenting arrangement ordered by the trial court. The mother's lack of trust of the father in this case manifested itself when I'll reserve the remaining of my 3 minutes for rebuttal.
Right,
Thank you.
Good afternoon, Your Honors. May it please the court, my name is Christopher Beauchamp from the Wilson County Bar, and I represent Joshua Michael Brown, the appellee in this matter. I have a firm belief, I suppose, that text messages are one of the worst forms of communication that we can engage in this modern day America. And I bring that up for two reasons. One, I did not have the luxury of being counsel while this trial took place, and so, like Your Honors, I get to read what occurred in the trial by looking at the black letter testimony of the parties and the exhibits that are presented. And then secondly, the reason why I bring up a text message is that the communication that my esteemed colleague alluded to between the appellant and her son was conducted via text message. And therein lies the significance of why we have the standard of review that we have in this court on an appeal from a trial by a judge sitting without a jury, is that Judge Thompson, in this case, had the opportunity to sit and preside over this case and look at the nonverbal communication and listen to the methods that the individuals testified to and the faces that the individuals had, and the conclusions that he made and the findings of fact that he made was not only based upon the words that came out of their mouth, but also upon how they presented themselves when they testified. And the primary argument that Mr. Edwards is advancing today with respect to this parenting plan that was formulated by the court is that it is an abuse of discretion, I suppose, that Judge Thompson ruled the way that he ruled. And the standard of review says that so long as reasonable minds can disagree as to the propriety of the decision made, the decision should be upheld. Well, I would point the court's attention to, or ask the court to direct its attention to, this passage in Judge Thompson's finding and ruling at the conclusion of the trial. And he states, for all these reasons, the court will adopt Mr. Brown's permanent parenting plan and designate him as Lace's primary residential parent and Mrs. Brown as the alternate residential parent. He states, he moves forward, had he requested, with respect to Mr. Brown, a traditional every other weekend schedule for Mrs. Brown, the court would have given that serious consideration. And moreover, as an admonition to Mrs. Brown, the court seriously considered limiting her parenting time with Lisa due to the provisions of Tennessee Code Annotated 36-6406. What Mother is asking in this case is for this court to reevaluate the facts and almost flip them upside down. And this isn't to say that Mother didn't do her fair share of parenting and was the primary caretaker of these children while the parties were living amicably with one another and the divorce wasn't pending. But that the appellant's position is to basically ignore this entire passage that Judge Thompson ruled and gave.
Let me ask you this, Mr. Beauchamp. What proof in the record will support that statement that you just read by the trial court? What proof that was presented, and we've got in our appellate record, supports those findings?
The trial court's findings?
Yes.
A couple of things. And I know that opposing counsel harped on this text message between the eldest child and mother related to Christmas vacation and dividing up Christmas time. I think originally it was scheduled where the child was going to be with one of the parents, and then it was offered that it would be divided, and she said, no, if you want to spend time with him, just don't worry about coming to spend time with me. And then the court made findings specifically as it relates to the eldest daughter, that there were instances in which mom and the eldest daughter were hanging out with one another in a room exclusively between the two of them, and the relationship between father and the eldest daughter had deteriorated substantially subsequent to the divorce filing, to the point of where there was a tremendous rift, and the court pointed to specifically the psychological damage that was revealed with respect to Anna, the eldest daughter, the 15-year-old. And his concern was that, and the admonishment was that if these sort of psychological issues that have presented in Anna start to manifest in Lisa, that the court would seriously, or mom needs to be concerned about losing more time with the daughter. And so, generally speaking, the evidence related to the deterioration of the relationship between Anna and her father and mother's contribution to that.
This was a case, I think, and correct me if I'm wrong, where the parties lived together until the divorce?
Yes, and on the day of the divorce filing, which I believe it was a trial that was divided up between 2 separate days. They weren't consecutive. One was in December, I think the 15th, and then the second day of trial was January 24th. And after the conclusion of that first day, I believe that mother and father separated, and because the house had sold, and they went and they were living separately with one another, from one another.
Okay.
And I will highlight one of the cases that Mr. Edwards had focused on in terms of joint custody being disfavored, or equal time being disfavored when the parties cannot effectively co-parent, the Rajendran case. There was a case that came out of this court in February of this year, the Bowden versus Crutcher case, Harold Bowden, Amber Crutcher, that was released on February 21st of 2025, and I would submit to the court that that case in particular really narrows kind of the breadth of Rajendran, where Rajendran said if the parents could not get along and live far apart, that under those circumstances, or under the circumstances of that particular case, joint custody was not appropriate. However, in this case, the testimony established that the child was healthy and happy after living some time under a 50-50 parenting arrangement. The parents' failure to get along apparently had no negative impact on the child. And I would submit to the court that based upon the testimony that the parties had both prior to the trial in their depositions and after their separation in December leading up to the January 24th trial date, is that Lisa was doing surprisingly well. And there wasn't any indication or testimony or evidence supporting any sort of physical, mental, or psychological malady that she was suffering as a result of the divorce or her parents' ineffective method of communicating and co-parenting with one another. And so I would submit that the case before your honors today is more in line with this Bowden versus Crutcher as opposed to the Rajendran versus Rajendran. And again, ultimately, the best interest of the child is the fundamental consideration that this court looks to with respect to whether or not the trial court's fashioning of a parenting plan is appropriate under the law, and whether or not that trial court abused its discretion. And, father filed a permanent parenting plan or proposed parenting plan asking for 50-50 time. That was what was awarded. And the court says in its ruling that it would have given father or considered giving father more time if he had asked for it. And so it really stretches the mind or the imagination to ask or to expect that this court would overturn it and flip it in the entirely different direction.
Let me ask you, the trial court makes a finding that the mom had caused psychological damage to the children. Where do we find evidence of that in the record? What expert proof establishes that?
Well, Your Honor, I would acknowledge that there wasn't expert testimony developing that particular issue. I suppose it was the general testimony about the inappropriate sort of de-evolution or breakdown of the relationship between her father and her, and the court connected that to the method by which mother had been parenting Anna. Now, I understand that there is no proof related to expert testimony establishing psychological damage
Was
in the
there
record.
any proof at all from the two older kids about their relationship with their father?
Yes, the older daughter did testify, and she testified that her relationship with her father was strained, and she did acknowledge that there were oftentimes situations where she and her mother would hang out with one another in their room with the door shut, away from their father.
And was that relationship strained because the father in this case, he initiated the divorce, is that right?
Yes.
Which I assume they thought was unexpected.
I can't speak to whether it was unexpected for the children or not. It would be my understanding that mother had a pretty fair indication that this was coming at the time that it was filed.
Didn't the daughter testify that part of the problem she had with the father's actions was that it ran afoul of her religious beliefs?
Yes. Yes, I mean, there was some testimony as it relates to, and the eldest daughter, Anna, was and is, as far as I understand, very spiritual and has a strong faith, and so there was some, I can't think of the right word, there was some animosity created by virtue of divorce not being an acceptable resolution when you're married and biblically speaking. And as it relates to the three remaining issues, specifically with respect to the question of the alimony award being appropriate, the denial of reimbursement for attorney's fees and then attorney's fees on appeal, I'll just touch upon briefly the alimony-related issue and the award with the court awarding mother, transitional alimony for 5 months. Again, I would submit to the court that the evidence that was presented to the judge in this matter and his application of the law to the evidence presented was not an abuse of discretion. The evidence and his ruling indicated that he believed that wife was intentionally underemployed and that she had the ability to have greater income and such that the court accepted the proposed exhibit of Sumner County teachers receiving between $50,000 and $70,000 a year, when at the time she was working about 70 hours per month and was earning right around $27,000. And so the court's consideration of what her appropriate income would be if she was employed fully was the correct thing to do, and its ruling on the alimony award based upon those findings was not an abuse of the court's discretion. So we would ask this court to affirm the trial court's determination in this matter, and I thank you for the opportunity to be here today. Thank you.
Counsel had mentioned the abuse of discretion, the standard of review, but as the court is aware, on appeal, appellate courts presume that a trial court's factual findings on best interest are correct. But appellate courts can overturn a trial court's best interest finding if the evidence preponderates against the finding. The trial court was concerned with Anna's, the 16-year-old's, and my client's close relationship. And the court did focus a lot of its attention on that. But it's admittedly by the trial court speculation that that strong relationship will affect Lace's well-being. The trial court says that, quote, given the significant amount of time that Anna will be spending with her mother, it is not only likely but probable that Lacey would be exposed to an echo chamber of criticism towards the father. And that's inconsistent with the trial court's finding that Lacey has a strong, healthy, and stable relationship with both parents. So the court it was pure speculation that that would have any kind of impact on Lacey. The father did not present any specific direct proof that Lacey's interests will be served best by ordering equal parenting time. And that's the law in Tennessee. The proponent of the equal parenting time has to present some kind of specific direct proof that it would be in the child or children's best interest. And that's as articulated in the cases of Darvaminish and Rajendran. And to address Judge Armstrong, your questioning of counsel, there was just no evidence of any kind of psychological harm or attempted psychological harm on Lacey at all. I mean, nothing. I know we focused a lot on the parenting plan, but that's not to diminish our issues raised about spousal support and attorney fees. It's just if your honors have any questions about those, I can answer them. But the focus for today's argument has been primarily on the parenting plan.
I do have one question for you.
Yes.
Were there two separate permanent parenting plans proposed by father in this case?
He did, and that's in my brief, the timeline. He had originally submitted a proposed parenting plan. If memory serves me correctly, he had suggested that the parties be named the joint primary parents with equal parenting time. And then after the first day of trial, he submitted another one where he requested to be named the primary parent. And that's the one the court adopted.
So that change of position occurred between the first and second days of trial?
Yes.
All right, thank you.
All right, thank you.
All right, you can call the next case, please.
In re Estate of Ruby Smith.